We are live. How you doing, Marshall?
Hi, Greg. How's it going?
Good. I
Just
am literally just walking in the door. I had a bunch of flight delays today, so I'm happy that I'm able to do this. Like literally, like 15 minutes ago, I walked in the house. Um, so we and I missed like several of these things because I've had just a ton of travel in the last couple of weeks, but my travel, I don't have anywhere to go. Like till May 6th, I'm home. It's like that's a long stretch for me. So I'm happy about that. Um, and the anyway, so I was at spoke at the ALA Texas chapter conference in San Antonio. And I stayed at the most haunted hotel in Texas, the Menger Hotel. Anybody's been to San Antonio? I did not have any incidents. I didn't see Teddy Roosevelt's ghost. I heard he hangs out at the bar. That's where he recruited the Rough Riders. And then I came home for a day, got a bike ride in, and then the next day had to leave. And I spoke at Suffolk Law School on Monday. And I did something that I have never done before. At Suffolk hosts this thing called LitCon, which is it's an excellent legal technology conference that they put on every year. And Suffolk Law School actually has one of the top legal tech programs in the country. So that's their signature program. They have really excellent faculty in that area, and they produce a lot of very good people there. They asked me to be the keynote speaker at this year's conference. I was a bit floored when I got that invitation. And then I felt like that was like 6 months ago. And then I was like stressed out about it and basically wouldn't do anything about it. I started working on it, but I was like, every time I would work on it, I would get stressed out because I speak on tons of panels. I speak about immigration law all the time. I speak about AI all the time. Um, but I never sort of like am imparting words of wisdom about innovation and entrepreneurship and so I talked about the history of legal tech, and I've been involved with my internet stuff started 1991 before the web and all that. So I actually had a lot to talk about as far as sort of the evolution of legal technology and kind of weaving it into immigration and how things changed in immigration and legal tech, how legal technology sort of like met the moment. Anyway, I think it went okay. And then I saw a YouTube video, and then I realized that I use a lot of filler words when I'm extemporaneously speaking. So I had actually written the whole thing out because I had a time limit, and then I realized even though I triple spaced it and I did all that stuff that I am just not good at reading. So I said, I know this. I mean, I wrote it out and I knew this. I wrote this. I mean, slides. I mean, I knew this stuff well enough that I knew I didn't need them, but I thought I would like not be stick to my timeline if I was just talking off the top of my head based on, well, it's not completely off the top of my head, but I mean, if I was not reading from a script. And I did okay. It came in a couple minutes longer than it needed to, but I watched it's on it's on YouTube, and I was watching, and it's like I sure say a lot, and I say like and there was some weird phrase that I was like saying over and over again, and I was like, why was I saying that? So anyway, that was Monday, and then I had a meeting in Washington. That was in Boston, and I went to Washington for a meeting for yesterday, and then I flew today and had all kinds of flight delays. So I'm a little tired, but I'm refreshed enough for this. So we do have some new. Well, what's going on with you, Marshall? You're a transplant now from to this. You're a Southerner.
Yeah, I'm still rooting for the Knicks in the playoffs, but yeah, I'm down south from
Yeah.
Siskind, Southern, deep south. I'm in New Orleans now. Yeah, came in on Monday, had my birthday Tuesday, and today's my first day in my home
Well,
office here in
happy
New
birthday.
Orleans. Yeah, thank you.
All right. So with that, we are going to do something a little bit different. Well, I tried this a couple weeks ago and I think it worked well, but I'm going to do it a little different way tonight, which is actually screen sharing to show you. So if this is immigration in the news, we're going to show you we're going to show you the headlines and then kind of talk about our take on it. So let me do that. Entire screen. There we go. There we go. Okay, it worked. I didn't just put an advertisement up, did I, for the law firm? But that's not actually what we're going to be talking about. Marshall, you had decided that the Visa Bulletin should be the first story of the week. So we have some news on that. So why don't you give us sort of the rundown of what we need to know about what's changed with the Visa Bulletin?
Yeah, so the biggest change this month from last month is that for employment-based adjustment of status applications, USCIS is now using the final action chart instead of the date for filing chart.
So here's the dates for filing chart for employment, and here's the final action date chart. So this is the one that matters.
Right. So the final action date, which is further back.
Final action date always matters, but for purposes of being able to file anything, you're only able to use this chart.
Exactly. So, you have up until April 30th to file, still under the previous month's Visa Bulletin. So,
what do we think about movement in the charts? Did we see much change from the April bulletin?
For family-based visas, yeah, we've got movement 6 months in a few categories.
Wow, that's a big jump. Yeah, I mean, I think that's sort of the theme right now is that there's two things that are going on. I think one thing is that just a lot of people are not applying on there. There's been big drops in a lot of categories as far as people coming into the United States, and there may be as well people that just decided they can wait. They're going to wait a little bit, but that's going on. And then I guess the other thing that's going on is that when you have adjustments paused at USCIS, and when you have visas that are not being issued because of a 75 country visa ban at the State Department, the way these numbers get set is you have see there I said there you have to have the State Department, either the USCIS or the consulates, report their need for a number for a particular person, and they are tracking all those numbers at the State Department, and that's how they determine what they're trying to essentially make sure that they don't go over they're trying to pace the movement based on how many visas are actually being issued, and their goal, to their credit, is to use up all of the numbers in in these categories by the end of the fiscal year, because they've had problems over the years where numbers get wasted because they didn't have a sufficient number of them. They weren't working on them quickly enough. So they're trying at the folks that write the Visa Bulletin to account for all of that. So that's my guess as far as why we're seeing big jumps. The good news about that is, obviously, if you're in one of these lines, this might be a time that you can you might be able to file for a while, and then you still might be waiting for a while, but it's really good to have an adjustment application filed if you can. And there may be also people that are not subject to the 75 country ban who are going to move a lot faster than they otherwise might. So some people are benefiting from it, and some people, it sort of reflects their misery. So don't be, you can't be too glib about the fact that the dates are moving, because the reason why they're moving is because because the system's is breaking. Not that they're being generous in any particular way. So we're on final action dates for employment. I have this just came out, the bulletin. So, and I've been traveling, so I haven't looked at it that closely. But anything that you wanted to report news wise as far as this chart?
No, the final action dates for employment-based immigration is pretty much the same. Just the biggest difference is that you're basing it off of
this chart. Yeah. So the dates of filing chart. Yeah, they are. And USCIS ultimately makes the determination, not State Department. This is sort of the dates of filing chart is based on what they predict they're going to be at the end of the by September 30th, and that's why they put it out. They usually don't. Well, I mean, they're usually not moving this chart very much during the course of the fiscal year because they they if they're wrong, they usually will coordinate with USCIS and pull it, but they are USCIS, I guess, is seeing maybe something that state is not seeing in terms of their expectations for how many adjustments they're going to work. Also, could be what's happening is there may be behind the scenes things that could be. We're going to talk about litigation, but this 39 country benefits pause, that could be affecting the USCIS adjustments. How soon if that pause gets lifted, then they are obviously going to be able to work a lot of adjustment applications that they aren't currently working on, and that could affect their thinking about this as well. Now, that is it, and there are rumors floating around. I can tell you, we're litigating two 39 country ban USCIS benefits pause cases, and we haven't had anything filed by the government in either of our cases indicating that anything's going around. But we're seeing sort of these anecdotal instances of people that are from the banned countries that are getting naturalized, and there's rumors floating around about a May 1st change that might be coming, but nothing that I would rely on. And we're certainly not filing anything with the court on any of this stuff because we have no actual reason to believe anything is changing. So I wouldn't get excited about it, but there could be that calculus going on behind the scenes. Honestly, when we get to it, I think we're going to talk about litigation toward the end of this. That the state the USCIS and the administration might be sort of calculating what's going to happen in the courts as they're doing things. So let's save that discussion for a little bit. But anything else we want to talk about with the visa bulletin?
I think we covered it.
Okay. Yeah. So other stories that we wanted to hit this week. So Holland and Knight. By the way, I'm officially an alum of Holland and Knight. Did you know that? And I never actually worked for Holland and Knight, but I'm technically an alum of Holland and Knight. And that is because the first law firm I worked for, and I talked about this in my big keynote this week, was a firm called Waller Lanston, and they were really nice people in Nashville. I was doing mergers and acquisitions and corporate stuff, and I was trying to break into immigration at the time. They didn't want me to, but they got bought last year. They merged into Holland and Knight. So officially, I get like Holland and Knight alumni stuff and all that now, even though I know nothing about what that firm's all about, except that they're very large. But they have an immigration news story this week that I did want to mention. There's some things that are going on with I-9s, and we never really talk about I-9s very much here, but I-9s and E-Verify. But this is sort of the administration strategy. So I-9s, for those who, most people probably know what they are, but these are the forms that every employee has to fill out on their by their first day of hire, and it's basically the employer is verifying your identification and your authorization to work. And it is essentially, this was the deal in 1986 where they made all the employers across America basically deputize them to participate in immigration enforcement. So it's been a long time. I still do a fair amount of consulting on this issue because I wrote a book on it that with my friend Bruce Buchanan, and still it's just got updated last year with the new I-9 form. But they have there was an announcement last week, and this is actually not on the story, of a massive increase in I-9 fines for employers. And then this is also talking about the something that's sort of related, which is ICE is expanding what it considers to be serious violations of the I-9 form, and coupled together, I think they paint the picture that the administration is planning on much more aggressively going after employers for I-9 violations to prevent them from hiring. Well, their administration probably wants to just prevent them from hiring immigrants, period. It should be prevent them from hiring people that are not authorized to work. But and by the way, if you discriminate as an employer against immigrants broadly and just say, I don't want to mess with complications with the I-9 forms, that's a form of that's a violation too, a discrimination violation that not being enforced by the Trump administration, but could come back and haunt employers later on. So I only wanted to mention that because it's a subject that doesn't get a lot of talk, but it is quietly a way that the administration can try and get, to intimidate employers and get them to perhaps take more restrictive policies on hiring immigrants than they might otherwise. So that's being said, we'll move on. And this was a story that I don't, it just happened recently, but this is part of the story, but the vote was today. So I'm just looking, this is March 30th. And we were looking, for this story, we were trying to pull it up, but it was actually paywalled on the Washington Post website. So there was a vote on this today. So basically, this technique is something that the House Democrats are using more and more. They started with the Epstein files, where basically it's called a discharge petition. And if you can gather a majority of members of the House to ask for a vote to happen on a particular subject, then the Republicans or whoever the majority leader or the Speaker of the House can't stop the vote from happening. It has to happen automatically. And in this case, they got 218 signatures to force a vote on TPS for Haiti to extend it. So we talk a lot about TPS every week here, and this is one that would force the president's hand on this issue. And I think we saw also there's a similar effort afoot for Burmese TPS also that when we were doing the research for today. But that passed on, so that reached 218 signatures on March 30th. They had the vote today. I believe it was today, and it passed by like 1 or 2 votes.
I think it's tomorrow, the vote. Final passage set for Thursday afternoon.
Well, maybe they have the votes. I think that's the news on there, is that this, but it's not going to happen this way. I just wanted to give a reality check, because first of all, it would have to pass in the Senate too, and it's not clear. They have a little bit more breathing room there, but there's probably a couple of Republicans over there that would vote for it, maybe. And then it has to actually survive a veto by President Trump himself. That's the problem on there. It could pass both houses of Congress, but the veto, you got to have 2/3 to override the president, and that's a lot more than 50 votes. So that's the problem with this. However, they didn't have 2/3. I don't think they had 2/3 of the votes on the Epstein stuff, and Trump basically saw the writing on the wall and decided not to veto the legislation that had passed. I think Stephen Miller would probably have a stroke if Trump basically said okay, if this actually passed in both houses. But you never know. The politics, politically, it's so miserable for him right now that honestly, if I were Donald Trump and I was trying to figure out how to change the narrative, this would be the perfect time to. He said in the past many times that he would like to see a big, beautiful immigration bill passed. And if he did that, he probably, would have a pretty major accomplishment on his hands. And some of the versions that are out there, there are things that you could. There are plenty of votes for tough immigration enforcement, and if you couple that with some things that the Democrats like, you could actually do something. But I'm not predicting that's going to happen. I'm just saying, if you wanted the Republicans to go in 2026 with saying that they actually accomplished something, They can claim right now they sealed the border. There's very few border crossings that are happening. That's actually a fairly significant thing that they can go to voters with. And that's always been what they said is as soon as we can, get the border under control, we'll start looking at immigration reform. Well, you can argue that they did it, and now it's time to start looking at reform. So maybe, but I'm just letting you know that that's a pathway for the administration if they really want to change the conversation. That would be a way to do it. And right now, between Iran and inflation and all the other stuff that's happening, they don't have a lot of good things to talk about. Okay, Marshall, here we go. The BI. So this is some just immigration. I know we have immigration lawyers that watch us. But this is a broader issue for the public. So this sounds like a very dry thing. This is from the American Immigration Lawyers Association. The Board of Immigration Appeals holds there's no right to a closing argument in a deportation case where you're arguing for basically your liberty in front of an immigration judge. Apparently, they say that is you have to show a due process violation in order to even get to give a closing argument, which kind of seems to me that that's what you would argue in your closing argument, that there's a due process violation. But this is just when we were talking about it before, this was my theory. I don't know if you have the same theory, Marshall, but my theory is that they're not really thinking this is going to affect what the decisions are actually going to be, because they have so stacked the odds against immigrants already. They just fired another 100 judges. There was big news in the last couple of days about big firings at the not at the BIA, but at the immigration courts, and that fire. So most of the judges that are sort of perceived as reasonable and basically giving people a fair shot, they have been giving them pink slips. Pink slips. I don't know if people who watch this know what a pink slip is, because I don't think they use pink slips anymore. But that basically just means that they have been firing judges who seem to be interested in being fair. I think is probably how I would describe it. And they have been stacked. They have new immigration judges that are coming in. Almost all of them have enforcement backgrounds. There are immigration lawyers who've been able to become immigration judges in stages of their career. That is clearly not happening right now, but that is and they're still down a lot of immigration judges. It's not a question of whether they need to change this rule in order to get more denials of these cases, which clearly the administration doesn't want anybody to actually be granted any kind of a win in immigration court. It's a question of how fast each case takes, because they are putting so many people into immigration proceedings, and it's I don't know what the wait is, 8-10 years to get based on the current numbers. And it's getting worse because of the shortage of there's fewer judges now than there were when Trump came in. This would take out probably a small amount of time in each of these cases, but cumulatively, how many more people can they order deported in a year if they actually take out this little piece of the process in each case, one after another on there? And I think this is all about just trying to do more cases, as opposed to trying to change whether people get a fair hearing or not, because they're not getting a fair hearing. And I don't think this is not going to make the difference for them whether they get approved or not. That's my theory. Got another theory?
That sounds pretty accurate, and I'm not trying to be cynical or gloomy about it, but I'm trying to make the machine more efficient in getting through this docket.
So this is a case I wanted to let people know is happening. There's a call for plaintiffs from the American Immigration Lawyers and American Immigration Council. They're thinking about a mass case on naturalization oath ceremonies that have been delayed or canceled for individuals. So it doesn't seem like there's not a lot of requirements for what they're looking for. This is for lawyers, so you can either tell your lawyer about it because there's a decent chance that this got missed or if you're a lawyer and you have clients that you think might be a fit here. So they're looking for ALM members who have clients who had naturalization oath ceremonies, not the interviews, the oath ceremonies that were canceled or taken off the schedule. And that this happened more than that they were not naturalized within a month of getting a favorable adjudication of their N-400. So that's what they're asking for. That's one group. And the second group is AL members with a client who has not been scheduled for an oath ceremony within a month of. First, I'll read it again. This is what I should be reading. ALA member with a client whose naturalization oath ceremony was canceled or descheduled and did not occur within 1 month of a favorable naturalization adjudication, or ALA members with a client who has not been scheduled for an oath ceremony within 1 month of a favorable naturalization adjudication. So if you're in one of those two categories, talk to your lawyer, tell them I think that AL and AIC will probably not charge for this case, if I had to guess. So this is this is one that could be an easy decision if your lawyer is an AL member and you meet these criteria. Have that conversation with your lawyer. If you are a lawyer, go through your case management system and see which of your clients have meet those requirements. So that was that, and I think that was it for everything except what we said we were going to talk about at the end, which is the lawsuits that we're working on. So I mentioned first that just to remind people that we have 3 cases that continue to be onboarding right now. If you're in these categories and you want to read more about them, you go to impactlitigation.com and go to onboarding cases. And then one of those cases is the 39 country banned benefits pause, which I mentioned a few minutes ago. We've filed 2 of these now, and we're working on a third. The reason why we're doing it this way, we're doing this as mass litigation, not class litigation. And the reason for that is, first of all, we want these cases to move faster. If you do class litigation, it's a lot more complicated and it would slow the whole process down because you have to go through class certification. Also, there has been pretty unfavorable Supreme Court jurisprudence regarding universal relief. So we're kind of taking the same approach that we took last year on the CVIS terminations for F1 students. And you may recall that in those cases, there were, I think, 6,000 to 8,000 students around the country where ICE terminated their CVIS records based on a hit in a criminal database, except that most of those cases, the hits were for things that were not actually serious offenses that made somebody inadmissible to the U.S. And in some of those cases, it was just a complete mistake that they were in there. Or we heard about people who were actually crime victims and were in the database because their name is in there as a witness and a victim. And that's how sophisticated and great their AI software was. It was combing all of this data, and basically, rather than that, and it also tells you that no one actually looked at anybody on an individual basis. They just basically fed them all in these names. I mean, they fed all these names in to CVIS and had somebody write a script and automatically pulled them all out. Anyway, getting back to why I'm mentioning all this is that you have there were about 100 of these lawsuits around the country. Our suit, we had about 300 students in one, but there were also a lot of these cases where there was just 1 or 2 students or a few of them that were included in it, and they all went in one direction. I mean, I think there might have been one case that they tried to get a preliminary injunction loss, but they didn't actually lose the case itself. It was just going to be stretching out longer. But like the other 99 cases, the judge ruled at the earliest part of the case. And so they got the message. quickly, and the policy ended. But that's sort of what we're hoping here, is that there are a couple other firms that are working on these 39 country benefits pause cases. And if we all get wins for our plaintiffs in these early cases, it could put some pressure on the administration to end the policy if they see it's fruitless for them, and they're going to they're going to lose over and over. And there's a good legal theory why this is it's basically, they're arguing, USCIS, that Section 212F of the Immigration Act, which is where all these travel bans come from, that allows the president to bar the entry of an individual or a group of individuals if he thinks it's in the interest of the United States. The key word there was entry. It is, so if the president can stop somebody from showing up at the airport or port of entry, there, but what we're talking about with benefits pause is that USCIS is not about entry. These are people that are already here and they're applying for this, one thing or another. And USCIS has said, well, the fact that the president is banning them from coming in because of, security concerns, that's enough of an reason for us to do more security checking and that kind of thing than would normally be the case. But it's a bootstrapping argument. And so far, there have been a couple of decisions by judges that seem to not buy that. There's a lot of old cases from the first Trump administration where judges said, yeah, that's not going to work. We sued on a number of cases in the first Trump administration about visa bans, particularly during COVID. And judges said, you have to issue the visa. You can't stop issuing visas because there's an entry ban. First of all, these entry bans are supposed to be temporary. Second of all, they're supposed to have exceptions that allow people to apply for exemptions. Anyway, we were pretty successful on those cases, and we were basically arguing similar theories for this case. So we have that going on. We have another case. It's a mandamus case for people that won the lottery, who are basically, their cases are just sitting there and they're not moving at consulates around the world, and they have to finish up their adjudications by September 30th. It's like Cinderella at midnight. If you you turn back to your carriage turns back into a pumpkin at that point. So they have to be done by September 30th, and they're not working on these cases at the consulates right now. Some folks are subject to the 75 country ban, and then there's just a lot of people who are just not subject to it, but their cases aren't moving either. We are going to be arguing for. We did decide to put some arguments in on 75 country ban folks about that being an unlawful reason for not working on the cases. So they're covered, but that's if you're a lottery winner and you're in that situation, that's what that case is about. And looks like those are, yeah. So that's basically. Oh, and then we have an earlier case with an amended complaint. So we're starting a new case, and we have another one. So those are the two main subjects that we're litigating there. We also have cases that are pending. And so our 239 country ban cases, the first two are pending. And we don't have any news to report on that yet. A lot of people want to know what's going on with our H-1B case, the $100,000 fee. And I can tell you that I don't have any news to report yet. Honestly, I really am surprised that we don't have a decision yet. The case was argued on March 8th in San Francisco, and the judge has had it since. So I'm guessing it's going to be a fairly long decision because the judge is taking a while on this. I'm hoping that's good news, but I'm not prognosticating on that. But that's so that case is pending. There are two other H-1B cases that are on the $100,000 fee that are going at different paces in different jurisdictions. So we're in San Francisco. The Chamber of Commerce, which lost with their district court arguments, they already had their appeals arguments in the DC Circuit Court of Appeals. I think it was even before our arguments, and I thought they did pretty well actually. The chamber and those are I thought things went better in those arguments than they did in the first set. But we're waiting on the Court of Appeals for them, and then there's a third case in Boston that the 17 state attorneys general filed, and I believe they wanted a motion for summary judgment route and not a preliminary injunction route. And that's, I believe, close to. I mean, they're going to have arguments soon on that case. I don't think they've had them yet, but that's moving along. So that's what's happening on that case. And I think somebody asked about Shahab Sky asked about whether. Oh, what do we think about the? I'll mention these. I'm not on here, and I should say that as far as developments but go, we're going to be doing, I think, with Chuck and Zach and others, update calls about these suits, and I'd like to have Zach on. Zach was the one that made the arguments in the Atlanta case, and in the Denver case, which is mentioned here. I don't think the suits are going to drag out, particularly any longer than other suits. But these cases typically there's this back and forth. You file your complaint, and then they get a response, and then you respond, and they respond, and there's set amounts of time. The government seems to take every bit of time that they can, so it's usually like 6 weeks, 2 months before all those deadlines are basically worked their way through. Occasionally, there's an amendment that needs to be filed. I don't know if that's going to be the case. That's one of the reasons why we're doing a third case, so that we're not slowing any of these other ones down. But my guess is that after those pass, then we'll get scheduled for the argument. So it'll probably be somewhere between day 60 and 90, if I had to guess, when we're going to see that. But like I said, I'd like to have Impact colleagues on with me that are actually that have been working on this. So that if you're in one of those cases, you can participate in the live streams that we do for the plaintiffs in those cases. But that's probably what we're looking at, if I had to guess. So I think that is it for our list of topics, unless I missed something. Did I miss anything?
Looks like we got everything on the list.
All right, folks. We're going to sign off, and I will, like I said, I should be like back to my normal calendar for a couple of weeks, and starting next week. But I will. We always pray for a slow week in immigration news, because it's usually not good immigration news that we're reporting. So we'll see what happens next between now and next week. But thanks for tuning in, and we will be back in 7 days. Bye.